Hi, this is Dan Whitney with the Whitney Law Firm in Towson, Maryland. Today we're going to talk about the issue of car dealers impersonating police. It sounds crazy, but not that crazy. It does happen. It happens here in Maryland, and it is currently happening. Well, it did happen in a current case that we filed a lawsuit in, alleging that, among other things, a car dealer's manager impersonated police in an effort to recover a vehicle after the dealer violated the Maryland spot delivery law and tried to force somebody to return their vehicle without giving them their down payment. So, of course, I file a lot of car dealer lawsuits here in Maryland. Dealers do all sorts of bad things. And this is a particularly interesting case, in no small part because how dumb the dealer was. I think that's the technical term, how dumb they were in the way they went about their police impersonation and harassment of our client. So what happens is this: as with many people, they go to buy a car, financing is not finalized at the time they make the purchase. And what happens is something occurs that's called a spot delivery. So what is a spot delivery? It means financing is not complete. And depending on whether or not financing does get complete, either the deal is done or the customer will have the right to cancel the transaction, redo the agreement on different terms. And if they cancel the transaction, they get the down payment back. So in Maryland, the spot delivery law says that if financing is not approved within 4 days, the dealer must send a written notice stating and disclosing the customer's rights. And then the customer will get that, read their rights, presumably, know what their options are, and they can decide, okay, financing fell through. I can either give the car back and get my down payment back, or I can renegotiate different terms. You have the choice. And the big thing is you have the option to back out, and you're not stuck negotiating with this dealership if the deal falls through or the terms you thought you were going to get, you're not going to get. And of course, if it's a spot delivery and you cancel the transaction, they have to give you your down payment and your trade-in back. So what happened in this case is it was spot delivery. They say you got to bring the car back. He brings the car back. There's 2 keys, and he goes to return the vehicle. Now, inside, once he goes in the office and he tries to return it, they say, oh, we can't give you your down payment back today. Well, the spot delivery law says you have to give the down payment back at the same time the car is returned. So he apparently gets in the car with the second key that he kept and drives off. So now at this point, the dealer has still not provided the 4-day notice that it's required to do under law, but they've decided to take matters into their own hands. So this is the interesting part and what is really atrocious behavior. What the dealer does, the client gets a text message either later that evening or the next evening. And what it says is, now it's a text message. Now, how many police do you know who text suspects and give them chances to do things before an arrest is made? I don't think that's how Baltimore County operates. But, you know, what do I know? I'm just a lawyer, not a police officer. Anyway, our client gets a text message that says, this is Officer Muclaster with Baltimore County Police. Before I process this report, you need to return the vehicle to name of the dealership. So my client gets it. He thinks, what in the world is going on? Why are the police texting me? He gets a little bit worried. And he's not quite sure what to do. Then, to make matters worse, he then gets an email from his employer. And the email says, hi, Mr. So-and-so. I just got a strange phone call from someone telling me they are a Miss So-and-so from Baltimore County Investigations. And it goes on to say, a woman claimed that she was investigating a car that's been reported stolen, and she was trying to track you down as part of this investigation. And she said she is with Baltimore County Investigations, but she's not a police officer, but she does a service for dealerships. This is bizarre. And as we'll discuss in a little bit, there are debt collection rules that protect consumers from harassing debt collection or alleged debt collection practices. So what does the dealer do? They violate Maryland spot delivery law. My client gets a text from somebody who says they are Officer Muclaster, and then their employer gets called and what certainly appears to be false information because there's no record that a police report was actually made about this vehicle. False information is provided to their employer. So eventually I am retained and we file the lawsuit. Now, Maryland has a Consumer Protection Act, which is very wide and broad and protects a lot of consumers. And it also has something called the Maryland Consumer Debt Collection Act. And just about every state, I believe, has a set of laws that require debt collectors to behave in manners that are not harassing and to also not do or to do certain things. So in Maryland, what some of these Maryland Consumer Debt Collection Act prohibited practices are include a debt collector trying to collect an alleged debt may not threaten criminal prosecution unless the transaction involved violating a criminal statute. Well, that didn't happen here. You cannot contact the person's employer with respect to a debt before you get a final judgment. Didn't happen. You may not disclose to anybody else other than the debtor or their spouse information that affects the alleged debtor's reputation. For example, saying to an employer, "We are looking for your employee in connection with a stolen car." That seems to impact somebody's reputation. You may not harass a debtor or an alleged debtor. You cannot claim, attempt, or threaten to enforce a right knowing that the right doesn't exist. So you know the car hasn't been stolen. You know you violated the law and you're still doing all these things to try and collect the car from the client. That doesn't seem to pass the test. And you cannot pretend, essentially, you cannot pretend to be a government official or lawyer if you're not. And I think we have some issues with that here as well. So when the text message was sent, and this is the part, also the part you can't even make up, when the text message was sent, of course, it came from a phone number. Now, there's a lot of spoof calls and other ways to hide your number. And I thought, okay, what would be the chances that somebody would actually use a phone registered to them to impersonate a police officer? Slim to none, you would think, but keep in mind, these are Maryland car dealers and anything is possible. So we hire a private investigator and he does some research and he confirms that the number is registered to an individual who is actually the general manager at the car dealer where the car was purchased and all this arose. So in other words, the manager used their own phone to impersonate a police officer. You can't make it up. It happened. We've got the evidence, and I don't think this is going to go well. So, of course, we file the lawsuit and begin to discuss the matter. The dealer has taken the position, essentially, this is no big deal. We don't think there's any legitimate emotional distress. And I tend to think differently. Of course, somebody who is threatened by somebody impersonating a police officer and is harassed through illegal contacts at their work to their employer would be upset. And I think that's a very normal feeling and one that a fact finder, whether it's an arbitrator or a jury or a judge, would probably not be sympathetic to. But that's just my take, and time will tell what in fact the matter is worth and what the fact finder thinks about this. So a few things to keep in mind. If a car dealer impersonates a police officer, that's a serious matter and you have legal rights under that, no matter what state you're in. And keep in mind, in Maryland, the debt collection statute applies not just to third-party debt collectors who are hired to collect the debt, but also first-party collectors who are going after somebody to collect a debt or an alleged debt that was made with the individual trying to collect it, like the car dealer trying to get a car back. That counts. They're a debt collector for the purposes of the statute. So just remember, you always have rights. It's important to be able to exercise those rights and fight back. If you have a case that happened in Maryland, please feel free to give me a call, and I'm happy to help if I can. Otherwise, find a good attorney in your state, give them a call, and hold the dealer responsible for their actions. Thanks for watching. Take care.